Two people commit the identical federal drug offense. Same quantity, same city, same year. One receives 3 years. The other receives 18. Neither judge made an error. The federal sentencing guidelines permitted both outcomes simultaneously. This is not a story about bad judges. It is a story about a system that Congress built in 1984 to remove judicial discretion entirely. The goal was consistency. The result was a machine that produces injustice with mathematical precision. Before the guidelines existed, identical crimes routinely produced wildly different sentences depending entirely on which judge handled the case. A defendant in Texas might receive 10 years. The same defendant in Vermont might receive 2. Congress decided this was unacceptable. What Congress created to fix arbitrary sentencing produced something arguably worse. A system so rigid that judges who believe a sentence is unjust are legally required to impose it anyway. Federal judges have testified that they feel like sentencing clerks. The guidelines created a mathematical grid. Criminal history on one axis, offense severity on the other. Where they intersect is your sentence. A judge adds points for a weapon, a leadership role, vulnerable victims. Subtracts for cooperation and remorse. The Supreme Court ruled in United States v. Booker at 543 U.S. 220 in 2005 that mandatory guidelines violated the Sixth Amendment right to a jury trial. The guidelines became advisory. Judges could now depart, but departures require written justification and face appellate review. After Booker, the gap between guideline sentences and actual sentences widened, but the disparity between defendants did not disappear. Studies show sentences for identical offenses vary by years depending on the judge, the district, and whether the defendant took a plea deal. The prosecutor controls the most powerful variable. Charging decisions determine the guideline range before any judge is involved. A prosecutor who files a charge carrying a 5-year mandatory minimum has effectively sentenced the defendant before the courtroom door opens.